This case starts like many others, but quickly spirals into a legal gray zone that raises one massive question. When does a detention go too far? A man walks into a bank. A fraud alert is triggered, and within minutes, he's handcuffed, placed in a patrol car, and held there for hours. But here's the twist. He's not technically under arrest. So, what happens when police push the limits of detention while continuing to question a suspect? And more importantly, were his statements truly voluntary or legally compromised? Stay with us, because this courtroom battle dives deep into Miranda rights, police procedure, and the fine line between lawful investigation and constitutional violation.
Although it was slow and annoying to everybody involved, there was a progression.
All right, this is a hearing outside the presence of the jury. It's a motion to suppress, and the motion to suppress is related to body cameras and to a statement that's alleged to have been made by your client.
Yes, sure. The body's basically, yes.
All right. State, call the witness, please.
State calls Alex Shawe.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am, I do.
All right, you can lower your hand. And did you put the little gray microphone on?
I did not.
No.
Right off the bat, this isn't a trial in front of the jury. This is a motion to suppress hearing, and that's critical. What the defense is trying to do here is block key evidence, specifically statements made by the defendant from ever reaching the jury. Why? Because if those statements were obtained improperly, they could be ruled inadmissible. And if that happens, the prosecution's case could take a serious hit. So everything you're about to hear revolves around one central issue. Were this defendant's rights violated during police interaction?
It's for the court reporter to hear.
Yes,
All right. Could you state and spell your name for the record?
first name is Alex, Alex. Last name is Shawe, Shawe.
All right. State, you may proceed.
Officer Shawe, were you on duty on March 7th, 2025?
Yes, ma'am.
Were you dispatched to any calls that day?
Yes, ma'am.
Were you dispatched to a call at 6919 South Zarzamora?
Yes, ma'am.
What location was that?
It is the bank.
What bank?
I can't recall off the top of my head.
Is that in Bear County?
Yes, ma'am.
Okay. So were you the only officer assigned to that call?
Negative.
Do you recall who was also assigned?
Officer McFadden.
Okay, when you get dispatched to a call, do you learn information regarding the call prior to your arrival?
Yes, ma'am. It's limited, but we get descriptions and the basic knowledge of what's going on.
So you arrived to the scene with basic information. Is that a fair statement?
Yes,
ma'am. On March 7th, 2025, were you equipped with body-worn camera?
Yes, ma'am.
To your knowledge, was it operating properly?
Yes, ma'am.
Okay, Your Honor, may I put?
Yes.
Now, this is where things get powerful. Body camera footage enters the picture. In modern courtrooms, body cam evidence can make or break a case because it shows exactly what happened in real time. But here's the catch. It's not just about what's seen. It's about how it was obtained and used. Even if the footage looks clean, the defense can still argue that the interaction itself violated legal standards. So ask yourself, does video evidence always guarantee fairness? Or can it still hide procedural issues? Vote for asterisk.
Officer Shawe, I am handing you a disc. What is this?
This is the body cam footage.
How do you recognize it?
We watched it earlier.
Is it a fair and accurate depiction of your body-worn camera on March 7th, 2025?
Yes, ma'am.
At this time, Your Honor, state would move to admit Officer Shawe's body-worn camera. That's going to be marked as the exhibit 1. 2. I'm sorry. It's going to be M1. M1. So sorry.
No problem.
This is the redacted one.
This is not.
All right, so M1 is admitted for purposes of this hearing.
Permission to publish, Your Honor?
Granted.
Thank you. When you arrived to the bank, did you detain anybody?
Not originally on scene,
Not originally on scene? What does that mean?
not at first. I made contact with the complainant first.
Okay, and then what did you do?
Spoke with the complainant who gave the better description and pointed out the defendant.
Okay, and based on that description, did you observe somebody matching that description?
Yes,
Okay, and then at any point did you detain a suspect?
yes.
Okay. What did you do next?
Walked him out of the building, placed him in the cuffs, into the back seat of the vehicle, and turned on the rear camera and the AC, and then Mirandized the suspect.
Okay, did you pat down the suspect?
Yes.
Why?
Just officer safety, make sure there's no weapons because he was going back into the vehicle.
Okay, and you stated you
This moment is huge. The officer admits the suspect was Mirandized while being detained, not arrested. That's legally interesting because Miranda rights are typically tied to custodial interrogation. So now the court has to determine, was this truly just a detention, or was it effectively custody? Because if it's the latter, then every question asked and every answer given falls under strict constitutional scrutiny. And this is exactly where cases like this start to get complicated. Asterisk.
Mirandize the suspect, is that correct?
Yes.
Why did you Mirandize him?
At the time, we had reasonable suspicion that a crime was committed.
At that time, was the suspect placed under arrest?
Negative. He was just detained.
Did the suspect ever ask if he was under arrest?
Yes.
What did you tell him?
I advised him that he was not under arrest and he was just detained.
What did you do next?
I just asked a basic question from the suspect's point of view on what was happening.
I'm playing state's exhibit at 1 minute and 37 seconds.
What's going on?
So, Officer Shaway, this is the bank you responded to, correct?
Yes, ma'am.
Okay, and this is when you stated you went inside and you talked to the Wells Fargo employees, correct?
Yes, ma'am.
Okay. Resuming state's exhibit at 2 minutes and 20 seconds.
That's fine. Okay, that's fine.
Playing state's exhibit at 3 minutes and 8 seconds. Oh.
Yeah, ready? There was a chat. You did everything on clock schedule.
The officer, you stated you patted him down. Is that what's being depicted here?
Yes, the officer gave consent to get everything out of his pockets.
Okay. Playing states exhibit at 5 minutes and 20 seconds.
Sit down. I'm turn the AC on and I'll be right back. I'm gonna put all your property and stuff. Okay, we're not worried about that right at the moment.
This moment is huge. The officer admits the suspect was Mirandized while being detained, not arrested. That's legally interesting because Miranda rights are typically tied to custodial interrogation. So now the court has to determine, was this truly just a detention, or was it effectively custody? Because if it's the latter, then every question asked and every answer given falls under strict constitutional scrutiny. And this is exactly where cases like this start to get complicated. Asterisk.
Pausing states exhibit at 5 minutes and 38 seconds. At this time, was Mr. Perez under arrest?
No, ma'am.
Okay. Did you ask him any questions prior to putting him in the patrol unit?
No, ma'am.
Resuming states exhibit at 8 minutes and 48 seconds.
Where's your right? So now you know. That doesn't mean you're under arrest. It's giving you a warning. That's all it is. It's your warning. Before you ask any questions, it's my duty as a police officer to advise you of your rights and to warn you of the consequences of waiving these rights. You have the right to remain silent. You don't have to make any statement or anything. Any statement that you make will be used in evidence against you or law or education. You have a right to have a lawyer present who advise you before and during any questioning by police officers or attorneys representing the city. You may have your own lawyer present, or if you're unable to employ a lawyer, refer will upon a lawyer free of charge now or any other time. If you decide to talk with anyone, you can stop talking to them anytime you want. The above rights are continuing rights which can be very clear in any state of the proceedings. We understand these rights. Yes. So what's going on? No, I don't know over here. Yesterday there. You do smart firework is high. I do nothing. I was trying to guess about shit. Okay, so you're doing it for a guy. You wrote your check. I mean, second time I come over to cash for this. So you already tried cash and bounce? No. I thought they just took it. They never give me the cash flow. And when was this? Today. I got it. Like earlier today? Oh, right now. I thought you said this is the second application. So yesterday I came, I cashed it, no problem, and then I got paid again today, and I cashed it. And they didn't say you anything? I asked any questions? No, they said, no. Sounds like. Yeah. Alright, so you came to cash the check. Alright, I got paid for it. Alright. So what you're doing on this contract work is so I'm bringing it out of my friends. So when you give it to them, they just didn't give it back. They didn't give any explanation. No. Okay. So for now, we're just gonna kind of chill and wait. Okay. We'll try to get you out as quick as we can. We're gonna clear everything up. So first talking then. Oh, this is impressive. That's just it's tactics. He didn't get in there. Yeah, that's not it before.
Pausing states exhibited 11 minutes and 17 seconds. Officer Shawway, after you read Mr. Perez his Miranda, did he acknowledge he understood them?
Yes, ma'am.
Did Mr. Perez waive his Miranda rights?
No, ma'am.
The prosecution is establishing something very important here. No threats, no promises, no coercion. That's their way of reinforcing that the defendant spoke voluntarily. But let's think about this. Does no threats automatically mean the situation wasn't pressured? Being handcuffed in the back of a police car for hours can itself create psychological pressure. So the real question becomes, is pressure always obvious? Or can it be subtle and still legally significant?
I'm sorry?
No.
No, he did not waive his Miranda rights?
Oh, he just understood. And then,
Did he agree to speak with you?
yes.
Okay. At any point, did you threaten the defendant to speak with you?
No, ma'am.
At any point, did you coerce Mr. Perez to speak with you?
No, ma'am.
Did you promise Mr. Perez anything in exchange for him to speak with you?
No, ma'am.
At any point, did Mr. Perez ask for an attorney?
No, ma'am.
I pass the witness, Your Honor.
Defense?
Yes. After you said that you received a nominal amount of information from 911 dispatch before you went to the bank.
Yes.
Did they tell you that Mr. Perez was a flight risk or dangerous?
In the note, it said that he was trying to leave the location.
And so when you arrived at the scene, was he running away or actively trying to leave?
No.
So whenever you got there, you confirmed that he was the flight risk. See. But as soon as you got there, you immediately put.
Yes.
Yeah, but you said that he wasn't under arrest.
No.
What if he would have? And he asked you a few times, said, "Am I under arrest?"
And I advised him no.
You told him,
He's being detained.
but he wasn't free.
No.
What if he would have asked you?
I would have told him no. He's being detained because there's reasonable suspicion that he possibly committed a crime.
At that point, would you have any evidence at all?
Not at that time, because I just spoke minimal to the complainant.
Did you look at the check or look at anything or verify anything that came with the 911 call before you did that?
I did not.
So at the time that you put him in custody, you had no reasonable suspicion about the crime.
I was just going off of what the complainant called for initially and said that it was a false check. That was flagged.
And then basically you talked to him for a couple minutes, then essentially you hand him the officer back, right?
Yes.
Then you didn't really have much to do with the case after that.
At that moment, yes.
Thank you. That's fine.
All right, any further questions?
Not for this witness, Your Honor.
All right, you may step down. All right, call your next witness.
State call Zachary McFadden.
All right, could you raise your right hand for me, please?
ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. And if you'll state your name for the record.
Officer Zach McFadden.
All right, state, you may proceed.
Yes, Your Honor. Officer McFadden, were you on duty on March 7th, 2025?
Yes.
What area were you assigned to?
The south side, South Patrol.
Okay. On the south side, were you dispatched to any calls?
Yes.
Where were you dispatched on March 7th, 2025?
To the Wells Fargo Bank off of South Zarzamora.
Okay, prior to arriving to the Wells Fargo on South Zarzamora, did you have any indication what you were being dispatched for?
Yeah, the caller called
dispatch indicating that a Hispanic male wearing a reflective vest of some sort was trying to pass a check, and that their fraud systems caught the check and they needed police to arrive there.
When you arrived to the bank, what did you observe?
My partner and I both arrived to the bank, and I observed a Hispanic male wearing a reflective vest in the parking lot, getting ready to leave in a vehicle. And so I went to go detain.
Wait a second, did you catch that? Officers initially detained the wrong person. That detail might seem minor, but it actually matters a lot. It shows how quickly decisions were made based on limited information. And in legal terms, that could raise concerns about the reliability of the initial detention process. If the first move was flawed, it naturally makes you question everything that followed. So now the defense has more room to argue. Was this investigation built on shaky ground? From the start?
Him and my partner went inside to talk to the caller. And that's when the caller indicated that I had the wrong person in custody. So he was released. And then we took the accurate suspect into custody and began questioning him.
Okay, so on this call, you stated that you had a partner. Were you all in the same patrol unit?
No, two different patrol vehicles.
Okay, who was the handling officer on this case?
I was.
So as the handling officer, were you the officer tasked with investigating the call?
Yes.
Okay, and how did you investigate this call?
Piece by piece. First, the suspect was written his. We read his Miranda rights, and he was advised that he was being detained on reasonable suspicion that we had a fraud case in front of us. I went and talked to the caller, which was the employee at the bank, who stated that their fraud system picked up a possible fraudulent check. And then once we determined the details from the caller, eventually I was able to get in touch with the owner of the check. And then the owner of the check stated that he didn't give consent for the suspect to be using his checks, or he didn't write any checks to that person. And it was from a very old checkbook as well.
Okay, so you stated the suspect was Mirandized. Did you Mirandize the suspect when y'all initially detained him?
No, when he was initially detained, it was my partner that Mirandized him.
Where were you when he was Mirandized?
I was inside the bank talking to the caller, I believe.
At that point during your investigation, was Mr. Perez under arrest to your knowledge?
No.
Why?
At that point, we were still gathering evidence, still piecing together this case. It took quite a while to piece it together. So at that point, he was just being detained while we.
Now we're hearing the justification. The suspect wasn't arrested because officers were still gathering evidence. This is a classic law enforcement explanation, but it walks a very fine legal line. Detentions are supposed to be temporary and limited in scope. Once they stretch into hours, courts start asking tough questions. At what point does a temporary detention become an unlawful holding? That's exactly the issue being quietly built here.
We were investigating a crime, and at the point that we had probable cause to make an arrest, he was under arrest. But at that point, he was just detained and read him his rights.
When he was initially detained, was he placed into handcuffs?
Yes.
Why was he placed into handcuffs?
That's just for officer safety and for the safety of anyone that we're dealing with. In law enforcement as a whole, but especially on the South Side, we deal with a lot of violent crime, a lot of firearms, a lot of weapons. So we found that both in trial and error and just in a general system of law enforcement, that anytime we leave people out of cuffs, there's a lot of opportunity to use weapons or to assault police. And when that happens, usually to get them into custody causes them to experience bodily harm, us to experience bodily harm, and also puts the public at risk as well for someone evading, someone shooting at us shooting towards somebody. So as a whole, we just put them in handcuffs and then frisk them for weapons.
Okay, perfect. So when you, prior to arriving to a call that you're dispatched to, do you receive information about what you may be coming upon?
Yes, we get verbally dispatched from our dispatcher over the radio saying that we're headed to the address and the general nature of the call just being that it's I think this one was a fraud was the title of the call, something like that. Then on our laptop computers in our patrol vehicle, we can see whatever details the call taker is putting on our call screen, where they're talking directly to whoever the caller is and they're typing out sentences on our computer. So I think if I remember right, an example from this one was that a Hispanic male wearing a blue shirt and a reflective vest was trying to pass fraudulent checks at the bank. And then another detail was that he was getting agitated or nervous or something to that extent and was trying to leave. And so those are the general details that I read before getting there, and which kind of led me to detain that one guy in the parking lot to keep him from leaving, because in my mind, got someone matching that description, at least with the reflective vest side of it, and he was trying to pull out of the parking lot.
Based on your experience, are the details in the key parts of, for example, regarding clothing, are those always accurate with what you
No.
observe on the scene?
No, in fact, I don't want to give a specific number, but I'd say very often they're about half right. And so sometimes somebody might say someone's wearing a blue shirt and red shorts, and then in reality they're wearing just the red shorts, or they're wearing just the blue shirt. So that's a human error thing. It happens with us as well. We're just human, and everybody makes mistakes, especially in a stressful situation. So if we can find one piece of evidence that kind of corroborates someone being in the area, someone matching description by race or ethnicity, someone matching description by clothing, we'll go ahead and start to at least have consensual encounters, but usually detained based off of that, based on severity of crime, obviously.
Okay. And on March 7th, 2025, were you equipped with body worn camera?
Yes.
Your Honor, may I approach?
Yes.
Sorry.
Oh, thank you so much.
You're welcome.
On March 7th, 2025, Officer McFadden, did you have Coban on your patrol unit as well?
We have the mounted cameras on the vehicle. Yeah, I think it's Axon at this point.
Okay.
Yeah, we had the mounted cameras on the vehicle.
And the mounted camera, is that the front of the vehicle and rear?
It's the front and then the prisoner compartment.
Okay, perfect. And he would have been marked as states exhibits M2 and M3. Do you recognize these?
Yes.
What do you recognize them as?
It's body worn camera footage that I reviewed today and then initialed, and then it is also, I believe, footage of the prisoner compartment that I reviewed and initialed as well.
Okay, are these fair and accurate depictions of your video on March 7th,
Yes.
2025?
Yes.
To your knowledge, have they been altered and amended?
Not to my knowledge.
At this time, your Honor, moves to admit would have been marked as states M2 and M3.
Objection.
All right, States Exhibit M2 and M3 are admitted without objection for purposes of this hearing.
Thank you, Judge. Permission to publish?
Granted.
Plain States Exhibit at 19 minutes and 44 seconds.
What happened on the bank's end is they had some sort of automatic system, warning that indicated that there was possible fraud. They didn't share with me how their system works. I don't know how that system works, but what they did from there after the automatic warning was they called the owner of the check and asked him if he had written a check. So I got a little bit more information than that, but I just want to kind of get your side of things here. So you do work at the you said where did you say you worked your primary job? Yeah. Okay. 6 months. Okay. Okay. Oh wow. Okay. So this check we have up here, do you know the owner's name? I did not. So walk me through. Let's pretend like I know absolutely nothing at all. Just walk me through the arrangement of what happened with regards to this check. What kind of work was it? Concrete work. Like residential or commercial? Okay. Okay, so did you complete the work? Did you complete the work? Okay, did you get started?
Pausing States Exhibit at 22 minutes and 6 seconds. At this time, Officer McFadden, was Mr. Perez under arrest?
No.
No. At this time, to your knowledge, was he already Mirandized?
Yes.
Who Mirandized him?
Officer Chavez.
At this time, did you coerce Mr. Perez to talk to you?
No.
Did you threaten Mr. Perez to talk to you?
No.
Did you promise Mr. Perez anything in exchange to talk with you?
No.
To your knowledge, was Mr. Perez speaking with you voluntarily?
Yes.
At any time, did you tell Mr. Perez he didn't have to talk to you?
I don't recall. I don't remember.
At any point with your interaction with him, did you Mirandize him yourself?
Yes, I believe I was watching body camera footage earlier today and I realized I Mirandized him a second time.
Okay.
After I Mirandized him as well as Officer Chavez later.
Why did you Mirandize him?
One, just the length of this call. It was several hours while we were trying to find a detective to handle this case. And so I like to dot my I's and cross my T's, so to speak. And also, once I felt that we had enough evidence on the table to move towards an arrest, I believe that's about the time frame where I Mirandized him again.
I pass the witness.
All right, defense, you may proceed.
Yes, good afternoon.
Afternoon, sir.
You mentioned that you do some things in terms of guns and keeping people in cuffs, especially in the South Side for safety in general. But in particular, there was nothing aggravating about this call that would necessarily require you to.
No, it's more of the area. I've worked that area pretty often, the Zarzamora and Southwest Military area. And I've dealt with quite a bit of death in that area. Not anything specific at the moment I'm going to get into, but when it comes to that Wells Fargo over there, they regularly have a off-duty police officer stationed over there, just because of the prevalent violence and then gun-related activity in the area.
Was there one there that day?
I don't remember. I know it was near closing time. I typically will see whoever's working that area. I don't remember if I saw him or not. It's been back in March, but typically we do see at least one of the guys out there. If we're working something on the street, they'll wave. We'll see each other. So
So, Mr. Perez, whenever you made contact with him, was actually like very cooperative, right?
yeah. Mr. Perez was cooperative, was nice, was by all accounts didn't give us any problems or was disrespectful or anything like that to my memory or when I was watching body cam footage today.
And so, after Officer Shawway Mirandized, he handed him to you, right?
I'm
You
say that
took him
again?
to put him in your car.
Yes, sir. Yeah, just because I was handling, we switched handcuffs so that Officer Chavez could get back in service, and then I placed him in my vehicle. Yes, sir.
And it's fair to say that he was in your car.
This is one of the most critical moments in the entire case. The suspect sat in the back of a patrol car for hours handcuffed, not free to leave, and continuously questioned. Even the officer admits it was a long time. And this is where the defense gains serious momentum, because duration matters. The longer someone is held under these conditions, the stronger the argument becomes that their will could be influenced. So ask yourself, how long is too long before it crosses the line?
For like over 3 hours.
Yeah, and I'm sure that was uncomfortable. And yeah, I wasn't happy about it either. But yes, he was in there for at least multiple hours. I don't know the exact time.
Maybe almost 4 hours.
It's possible. It was a long time. I think if you watch the video footage, you watch it go from daylight to nighttime.
Okay. And over the course of all this time, he was never under arrest until the very, very end.
At the point that he was going to be arrested, at the point that he was under arrest and was going to be booked, I advised him of that. After speaking with the detective and allowing the detective to make the final determination over the phone, that was when we made the decision he's going to be booked on this offense. I advised the Mr. Perez of the decision.
For those 4 hours he was in his car, did you ever offer him water?
I don't recall if I did or not.
I'm surprised you did.
No, I typically don't offer people fruit or water, only because I don't carry it for our folks that we're taking into custody.
You typically don't have people in your car for 4 hours.
It depends. If it's a critical incident, we could have people in our car for 6 hours or more. In those cases, we typically have a lot of resources on scene, and if there's a need to go get food or water, we will. And if I knew this case was going as long as it was, to be just perfectly blunt with you, I probably would have had somebody like let's take care of him some way. Let's maybe get him into a different chair, get him some water, something like that.
That's not what was done.
No, and even to my own frustration of trying to find a detective over all of those hours, it just went from 1 hour to the next. And keep thinking we're going to be done in about 15 minutes. We're going to be done in about 15 minutes, and it just kept
He was
going.
sitting in the back of your car all this time and handcuffed.
Yes.
So nothing.
No, he was not free to go. He was detained.
And so basically, you would talk to him for a bit, and leave, and come back. So it was basically like a 3-hour interrogation, right?
For the however many hours it was, yeah, he was being questioned after he was read Miranda rights, and so he also advised us both times that he understood his rights, which were read to him, and so yes, all the questioning that took place was willful on his own end.
And at one point, you actually have a conversation with one of your fellow officers where you say, this should probably be an at-large case or something, right? You say something along those lines.
I don't recall exactly, but yeah, you're reminding me of something. Yeah, that essentially you have a decision to go. We can either arrest on this because we have enough evidence to arrest, or this needs to be pushed to a follow-up unit, and they could file at large to issue a warrant for the arrest
And the
later.
reason I ask you that is because it at least showed an awareness on your part that like you're keeping him in custody forever. It's getting like kind of unreasonable at this point. So maybe you should let him go and follow up with an at-large case once you have a third investigation.
I do understand the questioning. So I would say if there was no progression in the case within those hours, then and we were just sitting on the same amount of evidence that we started with, the same amount of knowledge, the same amount of statements, then I could definitely agree with a statement like that, especially for the amount of hours we're talking about. But the reality of this one in particular was there was a steady progression, although it was slow and annoying to everybody involved. There was a progression where we had to get a detective because of the nature of the case being fraud, and that does go to a follow-up unit. And we also had to speak with everybody involved, the tellers at the bank, the employees of the bank, and then eventually get in touch with the victim, the owner of the checks, and get his statements over the phone, kind of establish who he is. Um, he had a lot of statements to make to me over the phone, and my main thing I was trying to establish was, is anything the suspect saying here credible? Because the facts changed quite a few times, or I'm sorry, the statements he was making changed quite a few times, and I understand that that could be a number of factors.
You're going past the question.
I apologize. I'm sorry.
And just one last question. At any point, up until the arrest, he was not, even though he was sitting in your car in handcuffs, he was not free to leave.
I'm sorry.
He was not free to leave.
No, he wasn't free to leave.
Never applied.
No.
But you told him that a couple times that he might be released.
I told him that, yeah, based off of whatever whatever may occur in my investigation, that he may be free to leave it that day. In my mind, I was going from, first I need to determine if we even have enough, if there's even been a crime committed. So when I'm talking to people, oftentimes, very oftentimes, we will put people in handcuffs that get released later because there's a lack of evidence. And then in other cases, it's a at-large case. And in both cases, they're released from handcuffs that day and they're walking. So I advise people of the possible outcomes for a case, just for the sake of, I don't want people freaking out or to be unnecessarily worried in my back seat, thinking that I am going to be arrested absolutely because I'm sitting here in handcuffs. Because very often people are in handcuffs in my back seat who do end up getting released that day without ever being booked. So I advise them of the possibilities.
One last question.
Yeah.
Going back to the very beginning, who was the officer that arrested the first person? Is that you?
The officer that detained the person who ended up not being the suspect, yeah, that was me.
Officer McFadden, you stated that you were waiting on a detective. Why were you waiting on a detective?
So a little complicated, but we have a lot of follow-up units on the department that their working hours end at about 4:30 in the afternoon, as a lot of businesses do. And I believe our fraud unit, or the unit that deals with fraud cases, was getting off at that time. The time that I was conducting a large portion of my interview, hey, I'm looking at the screen right now. It says 17:08, so it's after 4:30, and the next major detective unit would be night CID, and they get on at, I believe, 7 p.m., which would be 1900. So there's what's called a gap detective, a detective or a couple of detectives that bridge the gap between the follow-up units and then the night CID detectives. So during that gap, it seemed that there was a very heavy volume of cases coming into the gap, where I wasn't able to get either in touch with a detective at all or a detective that was able to handle the case.
Okay. And then at any time, did you allow Mr. Perez out of the car?
Yeah, I believe that we exited the car. Um, I know for sure at least once because uh, we switched him from a single pair of handcuffs to double handcuffs to give him a greater comfort, a little bit more motion in the shoulders. And I also allowed him the use of his personal cell phone to call work because he was concerned about missing work or something. So just based off of the length of everything, we don't normally do things like that, but it was a very long situation, and I wanted to give him every opportunity to call work or do whatever he needed to do that wouldn't compromise the case, but would also just recognize him for his human needs and things of that nature.
During the course of your investigation, who did you talk to?
Um, Several detectives and um, the victim. I don't remember the victim's name at the moment, but the owner of the checks, as well as the suspect, and then caller, the person who called 911, and then other employees of the bank.
And at what point did you determine that a crime had been committed sufficient to place Mr. Perez under arrest?
Based off of um, multiple conflicting statements from the suspect as far as the nature of how he got the check, what the check was for, his relationship to the writer of the check or the owner of the check, the nature of his work, um, the location that all of this occurred on. There was a lot of conflicting statements that were made by the suspect while I interviewed him. So there was that, but the nail in the coffin, so to speak, was the owner of the check telling me that the numbers on the check numbers at the top, were from quite a long time ago. They were like hundreds of checks off from his current checks being used, and that he did not give effective consent for anyone with the suspect's name to be writing or cashing those checks, and he didn't have anybody matching that description or with that name that had completed work that he claimed to have completed. And so it was all of those statements and piecing that together, notifying the detective of that, and then the detective determining we're making an arrest.
And do you recall approximately what time you were able to make that determination?
I don't. I just remember it was after dark.
And then regarding Mr. Perez, did you check on him at any point while you were waiting for people to call you back?
Oh yeah.
Yeah.
Quite a few times.
I pass it up, Mr. Honor.
All right, defense.
So the state made reference to 3 checks that you wrote about in your report.
Yes, sir.
So the check, probably not aware, maybe you're aware that the only check that was indicted was 1 check. The check covered that day, 674. Did you do
Your
any?
Honor, this is outside of the scope of the motion.
She asked about the other checks.
I did not ask about a check in this hearing.
All right, so what the court is focusing on is whether or not the statement the defendant gave was voluntary. And I believe that's the motion that the defense has filed.
Just a couple other questions around scopes. That all.
All right, any other questions from either side?
And from the state, Your Honor.
All right, is this witness excused for the purpose of this hearing?
Yes, Your Honor.
All right, you may step down. Thank you.
Oh.
All right, any other witnesses?
None from the state, Your Honor.
All right, then the court will hear argument. Defense is your motion. You may proceed.
Yes, Your Honor. I would encourage the court to grant my motion to suppress the statements that. Well, the evidence that was shown.
Now, the defense comes in strong, and their
Um,
argument is simple but
Several
powerful.
detectives.
This wasn't reasonable.
And
They're highlighting the
um,
length of
the
detention,
victim, I don't
lack
remember the
of
victim's
basic
name at the
comfort
moment,
like
but
water, and
the
the
owner of the
absence of
checks,
solid evidence early
as
on.
well as the
Essentially,
suspect.
they're saying
and
this
then
entire situation turned into a de
caller, the
facto
person who
arrest
called
without
the
probable
911,
cause.
and then other
And
employees
if
of
the
the bank.
judge agrees, those statements
And at
could be
what point
thrown
did
out
you
completely.
determine that
This is a
crime had
make or
been
break
committed
argument
sufficient
moment.
to place Mr.
Here shows that he was in custody for a total of 4 hours. He was never offered water at any point. Yes, he was Mirandized getting, but I don't think it was proper because they didn't have any reasonable suspicion or probable cause to even put him into cuffs or detain him at the beginning. They had nothing, not a thing. They said he showed up and arrested him. So I don't think that was reasonable. He was basically put into custody immediately. I don't see how you can be in a pre-arrest detainment for like 3 hours. That just doesn't seem reasonable to me. They could have proceeded a number of different ways, which they didn't. It's not really his fault that if it was in the South Side, that's what they do, or that they couldn't get a hold of who they needed to get hold of. They didn't have enough evidence. They put him in the cuffs. They didn't feel like they had enough evidence until like almost 4 hours later. So for that reason, I think it was all unreasonably done. And anything he said to them was improper.
Right. So, from the court's reviewing of the state's exhibits, I believe it's M1, M2, and M3, are parties stipulating that Mr. Pettis was Mirandized before he gave any statements?
Yes.
Yes.
All right. And do parties both stipulate that the Miranda warnings that were given were the appropriate Miranda warnings? I'm not getting to the fact of whether it was voluntary or not, but just that these are the standard and constitutional Miranda warnings that are given.
Words.
Okay. So then, defense, your entire issue is whether it was done voluntarily, correct?
Yes, sure.
All right. So how are you saying, or your belief that it's not voluntary?
Judge, they did read him his rights initially, but then they held him in custody 3 hours after, actually almost 4 hours after. So, I mean, I don't think it's reasonable that if they Mirandize you in the beginning and then they hold you for 8 hours, is that reasonable? And everything you say after that is, and if they have you in handcuffs in the back of a police car, this isn't like your typical type of interrogation that maybe would happen in a conference room with the police department, where a lot of times they don't put people in handcuffs, they just talk to them. This is by definition like a way more suggestive way to handle it. He was never given water. He was held in handcuffs for 4 hours. They never really gave him a chance.
So are you saying that the evidence presented that he was detained or in handcuffs for 4 hours?
Yes, sure.
And when are you suggesting that the Miranda warnings were given and the statement was made by your client within that 4-hour time period?
I believe so. The Miranda warnings were given pretty close to the beginning of the 4 hours. And the officer, my client, makes some statements initially after that, whenever he's transferred into a car. And then what essentially happens is the officer stops, then leaves, calls somebody, leaves him in the back of the car, comes back, does the same thing, asks him some more questions, leaves, comes back, talks to another officer, comes back. So it's like an ongoing
So when
process.
is you're saying that it was approximately 3 to 4 hours that he was detained? Or let me correct the record. You're saying that it was approximately 3 or 4 hours of him being in handcuffs in the patrol vehicle?
So he was in handcuffs 4 hours.
Okay. So the question the court wants answered, and I'll review the entirety of the videos, but what time frame from the last time he made him a statement to when he was Mirandized, what is the time frame between that? Does anyone know?
Are you talking about like the from first Miranda to second Miranda?
To the Mirandized with this last witness, when this witness Mirandized him, this is what
He didn't.
no, he stated,
No, they both.
When he arrested him.
Yes.
At the end
He
of the
said-
video.
yes. So what I want to know, and I will review the video, I want to know what is the length of time between Mr. Pettis being Mirandized and the beginning of the statement he's alleged to have given the officer and the ending of the statement that he gave the officer. Does everyone understand what the court is requesting?
Yes. And you mean when he doesn't say anything else?
No, just his last statement. For example, hypothetically, if he's Mirandized at the very beginning, after he's been placed in handcuffs and in a vehicle, I want to know, and I'll watch the video to see, but I'm trying to make sure that you all give me the argument because this is the crux of the issue here. So he's Mirandized, placed in handcuffs in the back of a patrol car, gives a statement. From the time he was Mirandized to the first statement of words he speak, what is the lapse in time? And then what is the lapse in time from the time he was Mirandized to the end of the statement that the state is seeking to have admitted? Those are questions that the court wants answers to because both parties have stipulated that he was Mirandized. So for the court, whether he is in custody or not in custody, he's been Mirandized. So then there are other issues that the court needs to consider to make a ruling on whether or not the statement should be admissible. And those are one of the issues I want addressed. So does anyone know the answer to those questions or?
If you just give us a couple of minutes,
Mhm.
Lauren does have some timestamps. We'll go through them and try to get them to you in a couple of minutes.
All right. And so defense, if you'll review the time steps with them as well. And of course, as I said, I just want to hear your arguments on that point and any other arguments you want to make. But I will most definitely review the videos as well. All right. The court will hear argument. Defense, it's your motion. So now that certain things have been established with regards to Miranda, I'll hear your argument.
Yes, Your Honor, I believe the court asked for some briefing on the timestamps, when things happen,
Yes.
of course, the video. And so I re-reviewed it,
Mhm.
and it looks like my client was Mirandized at 16:49 or 4:49 p.m. on March 7th. There was basically a few immediate statements to the officer, Mirandized him, then he was transferred to another car at 16:55 or 4:55 p.m. At which time there were statements made at that point.
All right. So I'm sorry. So you're saying he was Mirandized according to what you viewed at 16:49,
Yes.
and then a statement was given, and then he was switched to another vehicle at 16:55.
Yes, it's not re-Mirandized.
Okay. All right. You may continue.
then it looks like there's essentially continuous statements that are made, continuous questions with or without breaks until about 1914 on a timestamp, which I guess would be 714.
Yes.
So
So is 714 the conclusion of the alleged statements from your client?
I don't see any statements that he made after that.
After what times?
714, I guess I have like 228 or so.
What is that?
Timestamp. Yeah, that was, yeah.
Great.
Yeah, I was looking. So I don't see any statements that made by him after that.
Okay.
So it's about 3 hours. I think until they stopped asking.
All right. State.
Your Honor, regarding the timestamps, I was unclear whether Mr. Ambrosino was using the bottom like VLC seek or the top right corner. But I have on my review that Mr. Perez was first Mirandized according to the top right timestamp of the body worn and Coban videos. First Miranda was at 16:55 and 20 seconds is when Officer Shawway reads the Miranda warnings. At 16:56 and 1 second, Mr. Perez makes his first statement. He exchanges from Shawway's vehicle to McFadden's vehicle at 17:03:22 seconds. He is then re-Mirandized by Officer McFadden at, what is this, 19:44:45. And then his last statement I have him stating is at 19:47:30. And Your Honor, we would just ask that because he was Mirandized, he agreed to speak, that you find that it is voluntary. He was let out of the vehicle twice during this interaction, and as testimony heard, was that the investigation was progressing. It was just slower. They were during the gap period, and although he wasn't offered water, reasonable accommodations were made for him, such as allowing him out of the vehicle to call work. They allowed him to be double cuffed, which was at 18:14 and 18 seconds. I'm sorry, 18:12 and 12 seconds. And Officer McFadden did check in on him multiple times throughout the time and tried to keep him apprised of what he was doing, such as that he's waiting on the detective, trying to get in contact with the proper people. So we would ask that you deny defense's motion.
All right, defense, it's your motion, so I'll allow you final argument.
This judge, I don't think that this was a reasonable amount of time to have somebody pre-arrest taken. He was kept in the back of the car for at least 3 hours before he was actually put under arrest. There was no safety concerns, there was no other reason for him to be held in cuffs under those conditions. He was not offered water, he was not given anything to accommodate him. I understand there's issues in that part of town, but there's nothing extenuating about this particular case, with this particular client that merited that. So for that reason, I'd ask you to provide a statement.
All right, so what about being allowed access to his cell phone to make phone calls and being allowed out of the vehicle and being double cuffed for more comfort?
So I did see him get access to a call. I think most people are getting a call, one call, and something like that. With respect to the handcuffs, I believe he did that pretty early. That wasn't something that he did like 3 hours. He did it not too long after he.
Okay. All right, so what I'm going to do is, if there's no objection by the state or the defense, if you will leave the unredacted versions with the court reporter, I'll review them. And if you all are here tomorrow, well, I shouldn't say if you are here, I would like for all of you to be back here by 1:25, and I'll give you my ruling. and we're off the record. So if the court were to deny your motion, have you all reviewed the redacted version? And I know you'll still have objections if I were to deny your motion, but is there any issues with the redacted version if the court were to deny your motion?
The issues with the redacted version, well, she's not done with it now, right? Did you get it back? Or, because then you have to like, kind of turn it.
So if you all could.
Do it for you.
It's on the desk. It was
Oh.
done.
Okay, so my issues in the motion limiting with regard to that are basically extraneous offenses and
Mhm.
the other checks. That was really mostly.
All right, so this is what I want you all to. All right, so if you all could go upstairs and make sure that he sees the redacted version. And before you all leave here today, if you can look at it, and if there's some issues in there, if the court would deny your motion, let me know so that I can make rulings upon it so that the jurors, if they're here exactly at 1:30, we can start at 1:30.
Yes, Judge.
Okay. So if you will go up and grab that. We're going to go on the record. We're going on the record. Court is going to call State of Texas versus Carlos Perez. The cause number is 2025 CR 005408. Could I have parties announced for the record?
Lauren Espinoza and Megan Galloway for the state.
First, Ambrosino and Thomas Tiarina for the defense.
And are you Mr. Perez? All right. So where we left off yesterday is that there was a motion to suppress held outside the presence of the jury. It was related to whether or not the defendant's statements was admissible. I heard arguments from both sides, and then I wanted a chance to view the entirety of the exhibits that were admitted. The court had a chance to review those exhibits, and the court reviewed those exhibits last night. And this is what the court is finding. The court is finding that the officers were credible and truthful. The court finds that the defendant was handcuffed and placed in the patrol vehicle and read his Miranda rights at approximately 16:55:20, and both parties stipulated that that was the time. Testimony by the officers was that the defendant was not free to leave. Although the officer stated that the defendant was being detained and was not arrested, the court finds that the defendant was in custody. The court is finding that the parties have stipulated that the defendant was read his Miranda warnings at approximately 16:56:01. This was before the defendant made any statements. Although the first officer initially stated that the defendant did not voluntarily waive his Miranda rights, he later revised his testimony and specified that the defendant acknowledged the warnings and voluntarily answered questions. The court thus finds that the defendant freely and voluntarily waived his Miranda rights when he made the statement at 16:56. The court finds that the defendant was transferred to the second police vehicle at 17:03:22. The court finds that the investigation was proceeding very slowly, but the officer's explanation of why it was taking so long was credible. Although the length of the delay regarding the defendant's custody was excessive, the length and conditions of the delay were not so unreasonable as to render his statements involuntary. The court finds that the defendant was not deprived of food or water over an excessively long period of time. The court finds that the defendant was allowed to use the phone and have his handcuffs adjusted for comfort. The court finds and the parties stipulated that the defendant was again read his Miranda warnings at around 19:45:45. The officer testified that the defendant indicated that he understood his rights and that he waived his Miranda rights. The defendant then made another statement at 19:47:30. The court finds that there is no evidence indicating that the defendant's will was overborne. There is no evidence that the officers threatened or coerced the defendant or offered the defendant any incentive to waive his rights and speak to them. There's no evidence of police coercion or overreaching. There's no evidence that the defendant was intimidated, compelled, or otherwise coerced into answering the officer's questions. This court finds that the defendant made an uncoerced choice to speak with the police. He had the requisite level of comprehension, and thus he waived his Miranda rights. This court finds, therefore, that the second statement was freely and voluntarily given without being coerced. After examining the totality of the circumstances surrounding the interrogation, this court finds that both statements made by the defendant during the entire time period he was in custody were voluntarily and knowingly made. And it's the court's understanding that there are redactions that both parties agreed to if the court were to deny the defense's motion to suppress. Is that correct?
Yes, Your Honor.
And defense, have you had a chance to review those redactions?
I have, Your Honor, subject to objections that I might have for other reasons at the time.
And there it is, the court's final ruling. Despite acknowledging that the detention was lengthy, the judge ultimately found that the defendant's statements were voluntarily made. Why? Because he was Mirandized. He acknowledged his rights, and there was no evidence of coercion or intimidation. The court looked at the totality of the circumstances and concluded that while the situation wasn't perfect, it didn't cross the legal threshold to suppress the statements. This case highlights just how complex constitutional protections can be in real-world policing, where timing, conditions, and intent all collide in a high-stakes legal analysis. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdown.
All right, and what other, are there any other objections?
Well, Judge, if they're going to enter the body cam video as evidence, I think there are objections to that in general. There are out-of-court statements that, for the truth of the matter, asserted.
So you're going to be objecting to hearsay?
Yes, sir.
All right. All right, we'll take that up then at the time it is offered.
I guess I just need some clarity on which statements he's objecting to, because the version of the video that we have is party opponent's statement. So is he objecting to hearsay on the statements of his client? I just need some clarity on that.
All right, which hearsay statements would you be objecting to?
Well, Judge, I mean, the officers are here to testify, so I just don't quite understand necessarily why we would need their statements from the video. They're here to testify. I mean, we wouldn't
Well,
have the
I mean,
police
who's-
reports into evidence.
Whose statements are you objecting
The
to?
officer statements in the video.
Okay.
Okay, we can just proceed and take it up at the time that we offer it.
All right, so what we will do then is I'll bring the officers in, and then when the evidence is offered, both parties can make their objections and I'll make my rulings. Because at this point in time, I don't have the formal objection before me until it's offered.